Fundamental right and fundamental duties. Individual right and fundamental rights. The Constitution of England is unwritten. Hence, there is England no code of fundamental rights in the Constitution of the United States or other written constitution of the world. This does not mean, however, that in England there is no recognition of the basic rights of individual without the which democracy becomes meaningless. The object, in fact, are secured here in a different way. The foundation of individual rights in England may be said to be negative in the sense of the individual has the right and freedom to take whatever action he likes so long as he does not violate any rule of ordinary law of the England. Individual liberty is secured by the judicial decision determining of the right of individual in particular case brought before the courts. The judiciary is the guardian of individual right in England in elsewhere, but there is a fundamental differences. While in England it's the court have the fullest power to protect individual against executive tyranny. The courts are powerless as against legislative aggression upon the individual rights. In short, there are no fundamental rights binding upon the legislator in England. England, the English Parliament have being theoretically omnipotent. There is no law which is the cannot change it. As is the already said, the individual has right, but they are founded by the ordinary law of the land, which can be changed by the parliament like other laws. So there is no right which may be said to be fundamental in the strict sense of the term. Another vital consequence of the supremacy of parliament is that the English court has no power of judicial review over the legislation at all. It cannot be declared any law as unconstitutional on the ground of contravention of any supposed fundamental or natural right. Bill of Rights in the USA. The fundamental differences in approach to the question of individual rights between the England and the United States is the while the English are anxious to protect individual rights from the abuses of executive power, the framers of the American Constitution were the apprehensive of tyranny not only from the executive but also for the legislative, a body of men who is the long time being formed of the majority in the legislature. So the American Bill of Rights contained in the first 10 amendments of the Constitution of the USA equally binding upon the legislature as upon the executive. The result has been established in the United States of a judicial supremacy as opposed to the parliament supremacy in England. The court in the United States competent to declare an act of Congress as unconstitutional on the ground of contravention of any provision of the Bill of Rights. Further, it is beyond the competence of the legislator to modify or adjust any of the fundamental rights in view of emergency or a danger to the state. That power has been assumed by the judiciary in the United States. In India, Simon Commission and the Joint Parliament Committee, which are the responsible for the Government of India Act 1935, had rejected the idea of enacting declaration of fundamental rights on the ground of abstract declaration are useless unless there exists will and means to make them effective. But nationalist opinion since the time of Nehru report was definitely in favor of Bill of Rights because the experience of gathered from the British regime was that the subservient legislator might serve the handmaid to the executive to the committing inroads upon the individual liberty. That is history of demand for the fundamental rights in India. Regardless the British opinion, therefore the makers of our constitution adopted fundamental rights to safeguard individual liberty and so also for ensuring together of the directive to individual social, economic and political justice for every member of community that they are succeeded in the venture of testimony in the ardent observer of the Indian Constitution. In India, it appears that the fundamental rights have both created a new equality that have helped to preserve individual liberty. The number of rights cases brought before the high courts and the Supreme Court attested to the value of the rights and the frequent use of the prerogative writs testified to their popular acceptance as well. The classic argument against the inclusion of handwritten rights in a constitution have not been borne out of the India. In fact, the reverse may have been the case. So, the Constitution of India embodied a number of fundamental rights in the part 3rd in the Constitution, which are subject to exception to be mentioned in their head to act the limitation not only upon the power of executive but also upon the power of legislature. Court have power to declare as void laws contravening fundamental right. Though the model has been taken from the Constitution of United States, the Indian Constitution does not go to so far and rather effect the compromise between the doctrine of parliamentary sovereignty and judicial supremacy. Parliamentary sovereignty and judicial supremacy. On the other hand, the Parliament of India cannot be said to be sovereign in the English sense of legal omnipotent, for every fact that the Parliament is created limited by the written constitution enables our Parliament to the legislature on the object only subject to the limitation and prohibition imposed by the constitution, such as the fundamental right, the distribution of legislative power, etc. In case any of these limitations are transgressed, the Supreme Court and High Courts are competent to declare a law unconstitutional and void. Now, there is no blanket protect available to the laws inserted in the 9th schedule of Constitution Amendment on after 24th April 1973, the date of the judgment of Kesava Anand Bharati versus State of Kerala, and it shall be matter of constitutional adjudication by examining the nature and extent of infraction of fundamental rights by a statute sought to be the constitutionally protected. So far, the contravention of the fundamental right is concerned, this duty is specially enjoined upon the court by the Constitution, Article 13. By way of abundant caution, Clause 2 of Article 13 says, the state shall not make any law which take away or abridge the rights conferred by the part, or any law made the contravention of this clause shall to the extent of the contravention be void. To the extent our constitution follow the American model rather than the English, but the power of judiciary vis-a-vis the legislature are weaker in India than in the United States in two respects. Firstly, while the declaration in American Bill of Rights are absolute and the power of the state to be involve restriction upon the fundamental right of the individual in the collective interest had to involve in the judiciary in India, the power has been expressly confirmed upon the legislature by the Constitution itself. In the case of major fundamental rights, of course, leaving a power judicially review in the hands of judiciary determine the reasonable and restriction imposed by the legislature. Fundamental right under Indian Constitution distinguished from American Bill of Rights. 44th Amendment 1973, right of property. 44th Amendment 1978, the right of property. Secondly, by a somewhat hasty step, the Janta government headed by Morarji Desai has taken out an important fundamental right, namely the right of property, by omitting Article 19(1)(f) and 31 by the 44th Amendment Act 1978. Of course, provision of Article 31 first has by the same amendment has been transposed to a new article, Article 300A, which is outside part of 3rd of the Constitution and has been labelled as a chapter 4th and part of 12th, which deals with the finance, property, contract and suit, but that is not a fundamental right. While under the Congress government, Congress ruled for 30 years, the ambit of fundamental rights embodied in the part of 3rd of the original Constitution has been circumscribed by the multiple amendment bit to bit, the death blow to one of fundamental rights come from the Janta government. Net result of foregoing amendment inflicted upon the right to property are the right not be deprived of one property save the authority of law is no longer fundamental right. Hence, anybody property taken away by the executive fiat without the authority of law or a contravention by a law, the aggrieved individual shall have no right to move the Supreme Court under the Article 32. If a legislator makes a law depriving person of his property, he cannot be challenged the reasonable of the restriction imposed by such law, invoking Article 19(1)(f) because the provision has ceased to exist. Since Clause 2 of Article 31 has been vanished, the individual right to property has no longer guaranteed against the legislator in respect of any compensation for loss of such property. Article 31(2) in the original constitution embodied the principle that if the state make a compulsory acquisition or the requisitions of the private property, it must be make a law such as the law must be for a public purpose and the some compensation must be paid to the expropriated owner. Of course, by the 25th Amendment of 1970 during the regime of Mr. Gandhi, the requirement of compensation was replaced by an amount the adequacy of the could be no longer be challenged before the courts. Nevertheless, Supreme Court has the aggrieved individual might complain if the amount so offered was illusory or amounted of confiscation, but even such as the innocuous possibility has been foreclosed by the 44th Amendment. The short argument advanced in the statement of object reason of the 45th Amendment bill are deleting the fundamental right to property is that it was only being converted into the legal right. What is meant is that while Article 19(1)(f) and 31(2) of the original Constitution operated as the limitation on the legislator itself, 44th Amendment Bill installed the legislator as well guardian of an individual's right of property without any fetter of its goodwill and wisdom. But if the legislator could be presumed to be so infallible and innocent, this would be a good argument for the omitting all fundamental rights from Part 3rd. As it has been pointed out earlier, the very justification of putting limitation on the legislator by adopting a guarantee of fundamental right is this that history has proved that the group of human rights constituting for the time being the majority of legislative body are not always infallible, and that is why constitutional safeguards are necessary to Parliament protect the individual from legislative tyranny. Thirdly, the subsequent amendment or arena of fundamental rights has been narrowed down by introducing certain exceptions to this operation of fundamental rights, namely Article 31, 31B, 31C and 31D. Exception of fundamental rights. Of these, Article 31A, 31C are exceptions to the fundamental rights enumerated in Article 14 and 19. This means that any law falling under the ambit of Article 31A, a law of agrarian reform, or Article 31C, a law for the implementation of any of the directives or principles contained in Part 4th of the Constitution, cannot be invalidated by any court on the ground that it contravenes any of the fundamental rights guaranteed by Article 14. In equality before the law, Article 19, freedom of expression, assembly, etc. Article 31B, however, offered almost complete exception to all of the fundamental rights enumerated in Part 3rd. If any enactment included in the 9th schedule, which is to be read among the Article 31B, then such enactment shall be immune from the constitutional invalidity on the ground of contravention of the any of fundamental rights, but shall be upon the challenges on the ground of the damages of the basic structure of the Constitution subsequent to the 24th April 1973, the date of decision case Swanand case. The right of property is now considered to be not only constitutional nor statutory right, but also a human rights. Human rights have been historically considered in the realm of individual rights such as the right to health, right to individual, right to shelter, right to employment, etc. But now human rights are the gaining multi-faced dimension. Right to property is also considered very much a part of new dimension. Therefore, even claim of adverse possession has to be read that the concept with the expanding jurisprudence of the European Court for Human Rights, the court has taken unkind view to the concept of adverse possession. Therefore, it will have to be kept in the mind that the court around the world are taking unkind view toward the statutes of limitation overriding property rights, fundamental duties. Fourthly, by the 42 Second Amendment Act 1976, a fundamental duties mentioned in the Article 51A. Though these duties are not themselves enforceable in the court nor their violation in such the punishable, nevertheless, if a court before which is a fundamental right is sought to be enforced has to read all parts of Constitution, it may be refused to enforce a fundamental rights in the instance of individual who is patently violated any of the duties specified in the Article 51A. If so, emphasis of the original Constitution on the fundamental right has been minimized. Fifthly, a category of fundamental rights under our Constitution is exhaustively enumerated in Part 3rd of the Constitution. The American Constitution 9th Amendment expressly that the enumeration of certain rights in the Bill of Rights shall not be construed to deny or disparage other retained by the people. This rests on the theory of unalienable natural rights, which can by no means be lost to the individual in a free society. The guarantee of some of them in the written Constitution cannot therefore render obsolete any right which inherited in the individual even before the Constitution, e.g. the right to engage the political activity, but there is no such unenumerated right under our Constitution, as our observed in the early case of A.K. Gopalan versus State of Madras, the legislator under our Constitution being sovereign, except insofar as their sovereignty has been limited by the Constitution either expressly or by the necessary implication. The court cannot be imposed any limitation upon the sovereignty either on theory of in spirit of Constitution over that the natural rights other than those which is enumerated in part of 3rd Constitution. Any expression of the fundamental right under the Indian Constitution must therefore rest on judicial interpretation, and the Supreme Court has gone ahead in the direction by the enlarging the scope of Article 21. It should not be supposed, however, that there is no longer justiciable right to provided by our Constitution outside the Part 3rd. Limitations upon the state are imposed by her provision by the Constitution that these are limitations give rise to the corresponding right to the individual to enforce them the court of law if the executive or legislative violate any of them. Thus, Article 265 says that the no tax shall be levied or collected except by the authority of law, right following other provision of the Constitution. This provision confer a right upon the individual not to be subjected to the arbitrary taxation by the executive, and if the executive seek to levy a tax without the legislative sanction, the aggrieved individual may be have this remedy from the court. Tax legally levied must be refunded since the retention may be offered Article 265 of the Constitution. The new provision of Article 301A belong to the category. Similarly, Article 306 says subject to the provision of this part, trade, commerce, intercourse throughout the territory of India shall be free. If the legislature or executive impose any restriction upon the freedom of trade or intercourse which is not justified by the other provision of Part 13 of Constitution. The individual who are affected by such the restriction may change the action be appropriate legal proceeding. What then the distinction between the fundamental right included in Part 3rd of the Constitution, those rights arising out of the limitation contained in the other parts, which is equally justiciable. Though the rights of both these classes are equally justiciable, the Constitution remedy by way of an application direct to the Supreme Court under the Article 32, which is the itself included in Part of 3rd as a fundamental right. Differences between fundamental right and rights secured by the provision of Constitution. Which is itself included in Part 3rd as a fundamental right available only in these cases of fundamental rights if the rights follow from some other provision of the Constitution, says the Article 265 or Article 301. A aggrieved person may have his relief by a ordinary suit or by a application under the Article 226 to the High Court, but the application under Article 32 shall not lie unless the invasion of the non-fundamental right involves the violation of the some fundamental right as well. As a word, fundamental suggestion under the some Constitution, fundamental rights are immune from the constitutional amendment. In other words, they are conferred the special sanctity as compared with the provision of the Constitution, but the principle has been rejected by the Indian Constitution as the existing interpreted amendment of the Constitution themselves the judicial decision. Of course, no part of Constitution in India can be changed by ordinary legislation until the unauthorized by the Constitution itself. Article 4. But all parts of the Constitution except the basic feature can be amended by an amendment act passed under the Article 368, including fundamental right. This is proposition has been established after the history of its own. Amendability of fundamental rights basic features. Amendability of fundamental rights basic feature. Until the case Golaknath, the Supreme Court has been holding no parts of our Constitution was the unamendable, and the Parliament might, by passing a Constitution Amendment Act, compliances with the requirement of Article 360, amend any provision of the Constitution, including the fundamental right and Article 368 itself. According to the earlier view, thus the courts could act the guardian of the fundamental rights only so long as they were not amended by the Parliament of India by the required majority of votes. In fact, the sum of amendments of the Constitution so far made were affected with a view of superseding judicial pronouncement which had invalidated social and economic legislation on the ground of contravention and fundamental right. Thus, the narrow interpretation of Clause 2 of Article 19 by the Supreme Court in case of Ramesh Thapar versus State of Madras, Brij Bhushan versus State of Delhi was superseded by the Constitution First Amendment Act 1951, while the interpretation given to Article 31 in case of State of West Bengal versus Gopal, Dwarkadas versus Solapur Shipping Company and Dwarkadas versus Solapur Spinning Company, State of West Bengal, Bela Banerjee was superseded by Constitution 4th Amendment Act 1955. But the Supreme Court cried halt to the process of amending the fundamental rights through the amending procedure laid down by Article 368 of the Constitution by much debated decision of Golaknath versus State of Punjab. In Golaknath case, overruling its two earlier decisions in Shankari Prasad and Sajjan Singh cases. The Supreme Court has held the fundamental rights embodied in Part of 3rd had been given a transcendental position by the Constitution, so that the no authority functions as the Constitution, including the Parliament, exercise the amending power, and Article 368 was competent to amend the fundamental rights. But by the 24th Amendment Act 1971, Article 13 and 368 were amended to make clear that the fundamental rights were amendment under the procedural laid down Article 368, thus overriding majority of decision by the Supreme Court Golaknath versus State of Punjab The majority of decision Keswanand Bharti was appealed. The validity of this amendment has also overruled Golaknath cases, holding out that the competent of the Parliament to amend fundamental rights under Article 368, which does not make any exception in favor of fundamental rights, nor does Article 13 comprehend act amending the Constitution itself. At the same time, Keswanand case has also laid down that there were implied limitations of the power to amend and that the power cannot be used to alter the basic feature of Constitution. A big limitation that the state in the way of Parliament acting the special majority introduced the drastic changes of Constitution is the judicially invoted doctrine of basic feature, which can be eliminated only if a bench larger than the 13 judge of bench Keswanand case is prepared to overturn decision of that. The meantime, applying the Keswanand majority of Constitution bench, the invalidity clause 4 and 5 of Article 368 has been violated to the basic feature of Constitution. The fundamental right from the basic structure of the Constitution, any law that the abrogated or abridges such right would be violated of the doctrine of basic structure. Article 32 being the fundamental right in the duty of the court to ensure that no fundamental right over contravened or abridges by any statutory or constitutional provision. A violated separation of power need to rise such as the level that the apex court considered an abrogation of basic structure. It is the important the note that the separation of power between three organs, the legislative, executive and judiciary, it also nothing but a consequence of principle in equality inherent in Article 14 of the Constitution. According to breach of separation of judicial power, any amount of negation of equality under Article 14 stated thus the legislature can be invalidated of the basis of breach of the separation of the power, since such breach of negation of equality under Article 14 of the Constitution. Classification of the fundamental right. The provision of Part 3 of our Constitution, which enumerated the fundamental rights, are more elaborated than those any other existing written constitution relating to fundamental rights and cover to wide range of topics. The Constitution itself classified the fundamental rights under 7 group of the right of equality, right to particular freedom, right to against exploitation, right to freedom of religion, cultural and education right to property, right to constitutional remedy. Of these, right to property has been eliminated by the 44th Amendments Act, so only 6th freedom now remain in Article 19(1)(c) under Article 44th Amendment, and the right falling under the each of the 6 category are shown in table